Namaskar, welcome to Vanik YouTube class for your ASO examination. For your ASO examination. Okay. We'll be starting. I have taken some important questions for last minute revision. Okay. Last minute revision, we shall see some questions that are based on current affair, current developments will be also useful. So, current based extra question. You must have been preparing well at and target these exams. Hope God will bless you definitely. So keep patience. We shall start. Memory based questions on Indian polity. I have chosen some very important questions for your examinations. Look at the first question. 104 Amendment Act came into effect on, that is a very important act. You must have idea about this act. This act, dita parivartan hitla. Negi, gote parivartan hela amra, jo 334 re reservation for SC and ST in Lok Sabha and Vidhan Sabha ku 2030 jaye increase karaichi. So se purpose re ame taku amend karichu, article 334 को amend करिछु जोथरे हमें reservation को 10 years जाए 2030 जाए extend करिछु. So the required data उरे मन रखिबो केते जाए reservation extend हेछि केते वर्ष हेछि एवं को article amend हेछि. बाकी article 331 331 और 333 एगुरा भी repeal हेछि जोता कि nomination of Anglo-Indian members. So that Amendment Act came into effect on 24 January 2020. That is answer is B. 104 Amendment Act came into effect on 24 January 2020. 25th January 2020. Next question we shall be looking at, in which of the following state assembly election was not held? So you must have an idea that in February 2022, 5 states went into election. 5 states went into election at that time. So which of the following is not a state that is being asked also? So 3 states are there. Punjab, Manipur, Uttarakhand is there. Karnataka is not there. Another was probably Rajasthan and Uttar Pradesh also. So answer is D. Karnataka was not there. Another state was Uttar Pradesh. And yes, that was another state I forgot. But there were another state also. 5 states. Which is not a discretionary power. Now we shall come to the question number 3. Which is not the discretionary power of the President of India. Usually, in almost all exam, this type of questions usually is possible, is expected also. If you go through previous year questions, you'll find. So, discretionary means the power that are exercised by the President without the aid and advice of the Council of Ministers headed by the Prime Minister. So not the discretionary power of the President. Suspensive veto is a discretionary power. All the vetoes are discretions, obviously, to decide the day-to-day administrative decision of the caretaker government. Caretaker government means the government which is appointed after the dissolution of Lok Sabha for a brief period of time. Okay, after the dissolution of Lok Sabha and before the general election. After the dissolution of Lok Sabha and before the general election, जो gap period टा रहिला, से gap period रे जो government को continue करियो कुहा जाए तो caretaker government कहते. So caretaker government is very not as powerful as the regular government. So the president can direct, can decide the matter. Summon and dissolve the parliament of the session. That is not done by the president. It is done by the president on the advice of the prime minister and others. So that is therefore the answer is D. D. What sound is it? Which of the number 2? Which article of Indian Constitution speaks about official language of the Indian Union? Which language speaks about of the Indian Union, the official language of the Indian Union? That is 343. 343 is the language that speaks about official language. 343. There is also state language and also language to be used in Supreme Court and the High Court. That is 348. And the language that is used to be Supreme Court and High Court is English. Election 2022 Odisha was held. Anyone can say in how many pages? Panchayat election 2022 in Odisha that was held in February, and in how many pages it was held? If you remember, if you are preparing current affairs, then you can say yes, that was not in 6 pages, that was in 5 pages. If you remember, there are 5 pages. There was 5 pages, Panchayat election in India, in Odisha. That was done in 5 pages. So what was the date? 5 pages, I think, just a minute. So it was held on, yes, that was held in 5 pages, not 6 pages. That was in 5 pages. So kindly remember these questions. B. In 2022 Panchayat election in Odisha, election was held for how many Gram Panchayats? So we can expect all this type of questions basing upon the current relevance. You can expect these questions also in your upcoming examination. जो current development गुड़ा रहे, तारी उपरे सबू विभिन्न subject रो question base करिवो. तेणु पॉलिटी रिलेटेड क्वेश्चन गुरा आम एक्सपेक्ट करूचे से भल भाव मन रख भल चेक कर देख कौटी कौन जब आंसर भूल थी यू कैन गिव योर कंस्ट्रक्टिव कमेंट्स आल्सो बट एनश्योर दैट यू आर वेल एक्वेंटेड विथ दिस पैटर्न. ओके, नंबर 6 जीवा में. नंबर 6, इन 2022 इलेक्शन इन ओडिशा इलेक्शन वाज हेल्ड फॉर हाउ मेनी ग्राम पंचायत्स? So kindly remember that was C, that is 6,794 Gram Panchayats went to the pool in Panchayats at this point of time. Okay, so these are very relevant questions. I hope all of you are getting benefits from watching our YouTube classes. We always endeavor to help you, to keep you ahead of others. Okay, very good. That is Lilavati, you are right, 6,794. Abhilash, you are right. Lipun, you are also right. Very good, well prepared. So that is 6,794 panchayats went to elections. Okay, on which of the following date panchayat elections was not held? None it 5 pages thila. So panchayat, you can answer these questions. And anyone answer the questions? In which page? In which page it was not held? Yes, anybody? Okay, I'm telling you the answer. So it was held in 5 pages, 16, 18, 20, 22, 24. Then 14 is the answer. 14 the election was not held. The election began on 16th. The election began on 16th. So 14 answer is A. Okay. So that is your the things. Now we shall go to the next page, next questions. For how many urban bodies, the local bodies Odisha municipal election was held. Odisha municipal election was held. So it was about 109, 109, but 106 excluding urban local bodies. Odisha municipal election was held. Actually, that was 46, 106 means 47 municipalities plus 59 NACs. So, 46, that is 47. So, 106 plus 3 corporations. So, I don't think what was the data, but it was 109. It was 109. Please rectify that. 109 urban local bodies went to election that was held in 2022. Urban local elections. And then the next question, data de dichi. So, you dekhi debo. But it answer A hobo, but 109 hobo. Please, all of you rectify that. Please, all of you take care of it. Take note of it. Okay, now look at the question number 9. Which of the following not correct with regards to municipal election in Odisha in 2022? Lone, sabu data mu clear deichi, but can you say which of the following is not correct? Elections was held for 47 municipalities, 59 NACs, and you can say 3 municipal corporations. And the election was held in March 24, 25, 26. Which of the following do you think the answer? Can anyone answer? Can anyone answer? Yes, which of the following is correct? Which of the following is correct? Can you answer? Okay, that is Hrishikesh, B. Why B? B is okay, yes, B is right, yes. Option B, because election was held in 24 only 24, yes, you are right, 24. Election was held on 24, only one day, but only one day, it was not on several dates. So that is a point to be remembered, and so answer is B. Answer is B. Okay, now come to the major questions on 10. The power of state to recognize SCBC has been restored by. If the question is answered, then I will definitely say that you are well prepared. You are well prepared. I will give you 100%, 100 out of 100. If you answered the question, anyone? Question number 10. Can you exactly tell me? Can you exactly tell me which is the answer of these questions? That is, the power of state to recognize SCBC has been restored by which amendment, and along with the particular bill also? Yes. Hrishikesh, B. Yes, any other answer? Any other answer you are participating? Thank you. Yes, Ashish. You are okay. Then answer of your option then according to you is C. Okay. Then anyone can answer? No. Yes. C. Okay. C. No, I don't think the answer is C. The answer is D. You can check it. So D. 105 Constitutional Amendment Act and 127 Constitutional Amendment Bill. 127 Constitutional Amendment Bill, that was regarded as the 105. So I can check it also. 105 Constitutional Amendment Bill, and it was 105 Constitutional Amendment Bill, and that was also the bill number. What was the bill number? That was 105, 105th. So 105th, 127th Amendment Bill, that is 27th. You can take a note of this, D. Okay, so 10 answer will be D. Yes, Ashish, Abhilash, you are right. 105. So it is very important questions. We are expecting these questions also. You can get the answer. The bill number and Amendment Act is different because there are other bills pending in the Parliament, but this bill is passed fast. So that is why the bill number is different from the Act number. So 105 means the Constitution has been amended for 105 times since now till now. You can also get a question like this: by how many times Constitution has been amended? For how many times Constitution has been amended? The Constitution has been amended for 2020 since the end of 2021. So that is also a point to be remembered. Okay. Now come to a question number 11. That is the Act came into effect on 10th August 2021. The 105 Amendment Act came into effect on 10th August 2021. That is also a point to be remembered. The 10th August 2021, the Act came into effect. Like 25th January is the date of effect of the 104 Amendment Act, and that is 10th August is the date of effect of the 105 Constitutional Amendment Act. This is a major act because it has given power जो राज्य सरकार माननकु OBC SCBC को आइडेंटिफाई करिया पई एटा गोटे पावर दिया जाइछि एतरे 342B आर्टिकल को अमेंड करा जाइछि एवं राज्य माननकु क्षमता दिया जाइछि से माने SCBC एनुमरेशन करिवे. Okay, that is the benefit also to SCBC. Now they will be recognized by the center. Number 12, which of the following is included in the not included in the concurrent list? That is tolls. Tolls is in the state list, so you can prepare also. So have some idea about this. List upare take idea rakhibo. लिस्ट ऊपर गोटे दुटा क्वेश्चन आसे को लिस्ट रे कोन कोन अछि प्राइमरी जिंस ओराटे देखि देबो एवं सेतर गोटे क्वेश्चन हम एक्सपेक्ट करबा यूनियन लिस्ट स्टेट लिस्ट एंड कंकरेंट लिस्ट हाउ मेनी सब्जेक्ट्स 159 एंड 61 एंड 52 वेली को जाउची 100 अछि यूनियन लिस्ट रे स्टेट लिस्ट रे 61 अछि आ कंकरेंट लिस्ट रे 52 सब्जेक्ट्स अछि बोली को जाइछि एवं सेतिरे विभिन्न भल भल इंपोर्टेंट सब्जेक्ट्स गुडी को अछि तापर डी नजर दबो तापर हमें किछि क्वेश्चन एक्सपेक्ट करि परिबा. सो एटा आंसर बा डी. नेक्स्ट according to Election Commission of India, in order to be recognized as a national political party, a party must be treated as a recognized political party in how many states? पिलामाने national political party recognition पाया गले तीनोटी प्रधान क्राइटेरिया रही जो थी कि आमर एमती अच्छी कि गोटे पार्टी चारोटी राज्य रे 6% वैलिड वोट्स पाई 6% वैलिड वोट कि लोकसभा किंबा असेंबली लोकसभा किंबा लोकसभा रे दुईटी सीट पाई नहले 2% ऑफ लोकसभा सीट्स मिनिमम तीनोटी स्टेट रु पाई नहले चारोटी स्टेट रे राज्य दल भाव में आंचलिक दल भाव में रिकॉग्नाइज होती. So that is at least 4 states. C. So as of now we have 8 national parties बोले हमें कहूचे ऑल इंडिया नेशनल कांग्रेस, भारतीय जनता पार्टी, CPI, CPIM, and your nationalist Congress party, BSP, बहुजन समाजवादी पार्टी, ऑल इंडिया तृणमूल कांग्रेस, and National People's Party. So national party is recognized by the Election Commission of India basing upon the performance of the parties So that is the criteria. So if a party is recognized as a regional party in 4 states simultaneously, it will be considered to be recognized as a national party by the Election Commission of India. So that is also the answer C. Alright, next. Which of the following statement about Attorney General of India is not correct? Very easy question, you can do well. He is the first law officer of the Government of India. It's right. He is entitled to the privileges of a member of the Parliament. As an MP gets some benefits, some facilities, some privileges, so also Attorney General will get some benefits. He is a whole counsel for the government. Yes, is the counsel means advisor to the government. He must have the same qualification as are required to be a judge of Supreme Court. Yes. So all the points regarding Attorney General are right. So we can check the answer 1, 2, 3, 4. So is there that is answer is acha. He is the first law officer Government of India. He is entitled to privilege of a member of Parliament. He is a whole counsel for the government. He must have the same qualification as required to be a judge of Supreme Court. So not correct, not correct. Achha. Not correct to sabu correct achi re. This answer seems to be wrong. It is sabu correct. All the above are correct. Kindly take a note of that. Must have the same qualification required to be a Supreme Court judge. Yes, that is also right. It is all correct. So that is by mistake. It is not written probably. Next 15. In which of the case Supreme Court held that right to internet? It is also most probable case. In which case Supreme Court held that right to internet is a fundamental right? Most probable question for this upcoming examination. Remember, that is Anuradha Bhasin, BHASIN Bhasin case 2019 re Supreme Court held that a right to internet is a fundamental right under Article 19 re Anuradha Bhasin case. Okay, so that is the case. And right to privacy case is Maneka Gandhi case, triple talaq, that is Sahavanu case, and right to Maneka Gandhi case 78, and Indira Sahani case, that is popularly known as Mondal Commission case. So these are very popular cases in India. Kindly remember. So A is the answer. Anuradha Bhasin case 2019 re Supreme Court held that that right to internet is a fundamental right under Article 19. Which of the following is not considered part of the legislature of the state? Very easy question, you can answer. Which of the following is considered to be yes, Anuradha Bhasin case. Next is which of the following is not considered to be part of the legislature? Chief Minister is not a part of the state legislature. He is just a member of that, but he is not a part of it. So part means the Vidhan Sabha, Vidhan Parishad and governor are part of the state legislature, but Chief Minister is not a part of that. 17. Who has the power of annulment or suspension of acts and resolution of autonomous district council and regional councils? That is also autonomous district councils and regional councils are found in tribal districts like Assam and Tripura, Meghalaya, Mizoram, the 6 scheduled states. So in this state, the governor has the power to annulment of the act. The governor. 17A. Next is 18. Which of the following is not included? Which of the following is not included? That is that we have already covered. Tolls is the answer. Then next is yes, please. In which of the case? Then which of the following is not considered to be a part of the legislature of the state? The next question, governor. Then 18, question number 18, okay. Which of the following schedules to the Constitution of India provides for setting up of autonomous district council? That we have already discussed. 6th schedule. So 6th schedule is the answer. 6th schedule re district autonomous council था जंते हमें जिला परिषद अन्य जिला रे होची सेम तांकर district autonomous council. 6th schedule रे एटा होची district autonomous council और 5th schedule रे होची tribal autonomous council. Tribal advisory council TAC. 5th schedule state गुरा करे जोड़ा 5th schedule area गुरा करे TAC तेरी वे tribal advisory council और 6th schedule area गुरा करे district autonomous council तैयारी करा जाए जो माने major decision making body. Next, which law prescribes that all proceedings in the Supreme Court shall be in English language? Which law prescribes that all proceedings in Supreme Court? Yes, okay, Mamali, you are welcome. So that is co-article of it, B 348. I told you, I was telling you sometimes before also. I was telling you sometimes before that in part 17, 3 types of languages are discussed. One is union official language, another is state language, and another is court language or language to be used in Supreme Court and High Court. So you can see that under Article 348, the Constitution directs that the judgment of the Supreme Court and High Court to be delivered in English language. So that is the point, Article 348. But remember, there is no official language of the nation, of the country. Okay, that is answer B. So answer will be B. Okay, now next we shall go to next question, question number 20. It's a very important question also. Article 371A of the Constitution provides special privileges to which state? Nagaland, Mizoram, Sikkim and Manipur. It is the answer will be A. Answer will be A. So that is Nagaland. And remember, this article was added by 13th Constitutional Amendment Act. 13th Constitutional Amendment Act re it add karaitla ebong Nagaland by special provisions, and you remember that part 21 deals with certain provisions for special provisions for certain states including Jammu and Kashmir under Article 370. But as all of you know, 370 has been abolished that is with effect from 31st October 2019, and now there are a lot of states under 371 article. 371, 371A, B, C, D up to J. There are a lot of states. There are some number of states included under Article 371. So 371A deals with Nagaland. That is also a point to be remembered. So answer is A. Next is question number 20, question number 21. Which of the following department is not under the Ministry of Home Affairs? A type विभिन्न टाइप रा क्वेश्चन भी आसुची एमती टाइप रा बहुत सारा जिनसो गुरा आसुची. So Department of Legal Affairs doesn't come under Ministry of Home Affairs. So you can check it on internet also. There are different departments under the various ministries. Sometimes a question is also covered. So that is also a point to be remembered. Number D. Next, so I'm just showing you the area, not the question, because you will be prepared on that. So last minute रे से गुड़ा टी देखी दबो को ministry को मन सब रहउचंती को माने basic important अच्छी से ला देखी दबो finance ministry under रे क्या आछी home ministry under रे क्या आछी defense ministry under रे कौन department आछंती. So that may be a question also. Now look at a question, very interesting question. There are 4 institutions are provided: Finance Commission of India, Planning Commission of India, Investment Commission and Election Commission. It asks about the chronological order of the commission. Can you just guess which of the following will be the right answer? Anyone? You can answer. I'm waiting for your answer. Just prepare it. Question number 22, yes. Question number 22. Question number 22, what will be the answer? Yes. Just give me some of the hints about 22. Yes, Abhilash, that is option C. Okay, option C. Option C. Okay. Finance Commission and Investment Commission. Yes, you are right. So that is 25th January 1950 is the date of establishment of Election Commission, and it is March Planning Commission, and Finance Commission is 1951, and your Investment Commission is latter in both latter period in 2000 or regarding that like that. So that will be B. Investment Commission is a latter development, so B. Yes, you are right. Answer will be B. Next, the first delimitation commission. The first delimitation commission was constituted in 1952 under Delimitation Act 1951. There have been 4 delimitation commissions set up in India. One is 1952, 1963, 1973, 2002. There have been no delimitation commissions since 2002, and after 2031, after 2026, there will be a delimitation commission constituted. What does delimitation commission do? The delimitation commission determines the area of an electoral constituency for the election of MPs, Lok Sabha MP and Vidhan Sabha MLAs. So that is the things, and it recommends to the Election Commission of India. On the basis of the recommendation of delimitation commission, the Election Commission decides the territorial size of an electoral constituency. So that is a big, very important commission, constituted under Article 82 of the Indian Constitution. So the first commission was established in 1952. Okay, now you can come to the question. That is, who among the following stated that Indian Constituent Assembly in 26 January 1950, India was going to enter a life of contradictions. Life of contradictions, or various opposite thoughts, beliefs. That was said by B.R. Ambedkar. B.R. Ambedkar said this dialogue, made this statement that India will enter life of contradictions after on 26 January 1950. He was right. So that is A. Okay. Next, 25. 25. So that is the point. 25. Which of the following ground, which is the ground on which the Supreme Court can refuse relief under Article 32? So 32. Yes, that is Abhilash. You are right. So 25, which is the ground on which the Supreme Court refuse relief under Article 32? Which can refuse. That means Supreme Court cannot refuse. Only in few circumstances it can refuse. So the aggrieved party can get remedy from another court. एमती कही परिवनी सुप्रीम कोर्ट जदि आम आर्टिकल 32 अंडर सुप्रीम कोर्ट को अपील करवा ताल सुप्रीम कोर्ट एमती कही परिवनी जे तुम्हें अन्य कोर्ट को जाई पार बोली एग्रीड पार्टी माने विक्टिम. सो आंसर ऑप्शन ए इज रिजेक्टेड. द डिस्प्यूटेड फैक्ट्स हैव टू बी इन्वेस्टिगेटेड. ऐसा भी नहीं बोल सकता है, एमती भी कही परिवनी दैट नो फंडामेंटल राइट हैज बीन इन्फ्रिंज्ड. यस, Supreme Court can say no if the appeal जो थे appeal कराइतबो जदि से fundamental right violate ही न थिबो ताले Supreme Court तक मना कर दी पारे under Article 32 जो थे कि से various writs issue करिवो writs. So therefore answer option will be C. Option will be C. It can refuse in this regard. Okay, now we shall go to question number 26. Question number 26. Which of the following was defended by Dr. Ambedkar on the plea that it would be used as a matter of last resort? को आर्टिकल को आम्बेडकर कही जे एटा शेष उपाय बा शेष गोटे ऑप्शन हिसाब रे रहिबा दरकार किंतु रहू बोली बहुत सारा मेंबर माने in the constituent assembly opposed the inclusion of this article, but Ambedkar supported the article, saying that at least it would be kept as a matter of last resort, last option. So which article he was referring to? He was referring to Article 356, under which the state is brought under President's rule by the center. So that is C. Which article was used to be a matter of last resort, last option, and it was under Article 356. 356. The fundamental rights guarantee. Next we shall go to 27. Question number 27. The fundamental rights guaranteed in the Constitution of India can be suspended only by a proclamation of a national emergency, an act passed by Parliament, an amendment to the Constitution, judicial decision. A proclamation of emergency. Only during national emergency, the fundamental rights can be suspended. Under Article 358 and 359 deal with the suspension of fundamental rights when national emergency is imposed. So remember that this is done by only when there is a proclamation of national emergency. What does it imply? It implies that the fundamental rights cannot be suspended during President's rule and financial emergency. Is that clear? So that is a must point, remember. So that is a proclamation of national emergency. 27. Now 28. Which among the following states of India has the largest number of seats in Legislative Assembly? Which of the following states? Remember, West Bengal is the second largest assembly in India, second largest after Uttar Pradesh, because it is about 293 seats. So that is the largest one, and later Tamil Nadu, then Bihar, then Tamil Nadu, then Madhya Pradesh. So go through the list of assembly seats in India. You can also expect a question on that line, because elections are being held, and today we are focusing on the questions are being focused on the current status of everything. So always focus your idea on current status of everything, like the strength of legislative assemblies in India and in the descending or ascending order. So you can see that is West Bengal. Remember, West Bengal is the second largest legislative assemblies in India after Uttar Pradesh. Next, 29. 29, we shall come to 29 question. Judgment of the Supreme Court in the Visakha case. In the Visakha case. In the Visakha case, judgment of the Supreme Court in the Visakha case. Visakha case is a very prominent case that was first lodged in a Rajasthan district court, and it was decided by the Supreme Court later. It is related to most sensitive matter in India, that is the sexual harassment of women in workplace. So that is related to sexual harassment of women in workplace, and it was a very trend-setting legal case in India. After that, various stringent measures were taken to restrict this type of inhuman tendency. Okay, that is 29. So answer is A. Yes. Okay. Very good. Doing well. Papun, Sagarika, yes, all of you are right. Very good, well done. Now, that is 30. Which of the following statement about the ordinance making power of the governor are correct? It is a discretionary power. The governor himself is not competent to withdraw the ordinance at any time. So that is also is not competent the governor himself is not competent to withdraw the ordinance at any time. Both of them are wrong because ordinance making is not a decision making and discretionary power, because he can issue ordinance only on the advice of the chief minister, and also he cannot withdraw the ordinance himself. Rather, he has to seek the advice of the chief minister before withdrawing the ordinance. So he cannot do anything with regards to ordinance, I think. So that is the ordinance making, as both are neither of them is incorrect. So the answer will be D. Neither will be incorrect. So answer will be D. Okay. So question number 30. Now we shall come to question number 31. Okay. Are these questions very good? Okay. These are very required questions, or very yes, you are right. Yes. So do you think these questions will help you, or they are quite valuable, or there should be certain advanced questions? Okay, Abhilash, thank you. So proceed on. We are updating the questions, and I will try my best to provide you more and more valid questions for the upcoming ASO examinations. Okay. So that's what is the answer to 31? Which one of the following amendments to the Constitution of India has prescribed that Council of Ministers shall not exceed 15% of the total strength of the members of the House, people of Legislative Assembly in the state? Which amendment? Which amendment provided it? Okay, so 31 is A. Yes, excellent, well done. So that is A. 91st Amendment Act 2003 restricted that the number of ministers in a government shall not exceed 15% and shall not be less than 12 also. Thank you. That is also very important. 97th Amendment 2003. Okay. Now we shall come to 31, 32. The right to, very important questions. Right to Article 21 of the Constitution of India includes the rights of transgenders, rights of craniopagus twins, rights of mentally retarded women to bear a child. These are new rights which have been included in Article 21 according to the interpretation of the Constitution. Do you know, can you answer these questions? 32, option B. Okay, option B. Abhilash, yes. Okay, any other answer? 32, yes. Can you, who are prepared, those who are prepared on current affairs, they can answer it, otherwise not. Option B, D, yes, option D is the right answer. That is Mandira, you are right, Mandira is right. Mandira is right. That is Mandira. That 1, 2, 3. All the rights have been included. Yes, Papun, you are right. Yes. So 32 will be answer D, because remember also. Okay. So answering is not that problem. Answer wrong, but I may answer those. So always try to have a courage and to have an interest to answer the question. You are right, but remember, all the rights are included under Article 21 by the Constitution, by the Supreme Court recently. So these are recent rights, those who have been included in the Article 21. So that is D, answer D. Okay, 33 and 33. 33 will be our last question because time is going to be off. Which of the following statement about 73rd, 74th Constitutional Amendment Act are correct? Number 1, it makes it mandatory for all states to establish a 3-tier system of government. Representatives should be directly elected for 5 years. There should be mandatory reservation of 1/3 seat in all panchayat at all level for women. Can you answer question number 33? Anybody? Yes. Yes. Okay. Okay. A, Shakti. A means 1 and 2. Okay. Next. No, C. it makes mandatory for all state to establish theater. It's not, it's incorrect. It's not, it does not make mandatory, because there may not be theater structure for states having less than 20 lakh population. Having 20 lakh population जो state अछंती से state रे 2 tier रही पारे 3 tier रही बनाई बोली कुआइच. Then that is not mandatory. Mandatory means what? Compulsory. Then representative should be directly, yes, it is right. There should be mandatory session, yes, it is right. So answer B. Somebody answer B it? Yes, yes, sorry, yes, okay. Those who have answered B, it is right. Those who have answered B, yes, you are right, sorry. So B, okay, very good. Well done. Friends, wish you all the best for your examination. If time permits, I will भेटिबा. Auri भल question आनिबी, upcoming questions I am got prepared. Okay, next class tomorrow. Next class point time I will see you back if I get time before your much coveted examination. But if I don't, so I am advance तुमको blessing दूची. God bless you and God make you most successful in the examinations. Thank you very much to all of you.